Good afternoon, folks. This is TJ, and this is UR Law's Premium Member Web Q&A session for February 9th, 2021. Welcome. I'm going to start off with our usual method of starting off with a prayer for those who wish to join in. In the name of the Father, Son, and the Holy Spirit. Lord, thank you for all your blessings and of your wonderful things you've given us to be able to come together. We know where two or more together, you're there with us, and that's the purpose of our ministry, is to bring together people to work toward a common cause of having greater success in dealing with protecting our freedoms. And that's an essential thing that we know that you've given us. But of course, we only get what we accept from you. And we're going to talk a little bit about that today. So, Lord, thank you for the blessings of good friends, good members, people who support one another so that we can all become a much more powerful group together. In Jesus' name we pray. Amen. Just a brief legal disclaimer. As it says on your screens, our events are for the void of legal advice, which means essentially we don't give legal advice here. Please don't expect that. And you'll see a lot greater success. So just keep that in mind. We also want to remind you that even though we're talking about legal issues, it doesn't necessarily mean that we're giving legal advice. If you ever take it as such, then you've taken it the wrong way. Sometimes you do need to talk to an attorney. Sometimes you do need to consult with other counsel. Sometimes you need to talk to your tax guy about a tax issue. We're not here to tell you what to do or not to do. We hope that you would learn to take more responsibility for your actions, take more responsibility for your outcomes. If you do have counsel, you're directing them, not the other way around. And that you are law. That's the whole theme of our website. But that means taking responsibility. Benjamin Franklin said, we gave you a republic if you can keep it, with the emphasis on you. It's up to you. It's not up to the government. It's not up to somebody else. It's not, waiting for what they do in Washington, not waiting for this secret Trump revolution to happen that may or may not happen. It's about what you still do, and do you recognize when others are violating those rights, and do you know how to deal with it correctly? If you don't master that how to deal with it correctly part, that's where you'll run into a lot of problems, which I know we're going to talk about in more detail today. A reminder that we have a testimonial blog. If you go to our testimonials on the website, you will see, let me get over there to your law. And just to be sure you're checking that out occasionally to see if we update it. We do frequently add blog testimonials. So if you click on here on blogs, it will take you over to various articles that we put up. Then we have categories as well, and you'll see ones that, for example, it says, let's see, I'm trying to find it now. Testimonials. See, once you click on testimonials, you'll see a testimonial there, and then you'll see a bunch more. And there's a bunch of, you can also click on the category box here as well for different subjects that we put up articles about. A lot of people forget this is here, and then go through case after case after case after case after case after case of successes that some of which might motivate you and inspire you to take. And one thing you'll find about these, that I find the most common thing about all our testimonials, is it's not so much what we told them to do, because we generally don't get in there and say, oh, next you do this, next you do that, next you do this, because we don't know what your documents are. We don't know the conversations that you've had. We don't know what you've done in the past. We just try to give you the big picture so that you can navigate the small picture, because we cannot possibly do it for you. It's not what we do here. We're here to teach a man to fish, not to give him a fish. Now, reminder about using our Telegram group. Telegram.org is our instant messenger that we like to use. It is not our product, so we don't control it, although we do control who has access to our group on that software application once you're in there. So keep that in mind. We have sometimes people email us and say, well, I can't log in. What do I do? I said, contact them. It's not our product. But you should be able to get that's an independent chat platform that's available to millions of people. But we happen to have a group within that that's available, plus the individual connection with us if you want to ask me a question. That's a good way to ask quick questions. Do not give me 8-page documents on there, stuff to download. I'm looking at it on my smartphone quite frequently. I can't read fine detail. But you can give me some basic questions there that we can fire back. And then in the discussion group, which is available to all of you, once you can request to join that once you become a premium member. Or you can go to the down here on the I'm looking at the premium member page now, skim all the way down to where it talks about communicate with us effectively for support. This tells you the ways to do that. You got a website login issue, go to support@urlaw.org. That does not come to me. Don't ask me. Don't ask her class questions. She's going to help you with a login, credit card, those kind of issues. If you want to join meet me on the Telegram group, here's the link to do that. It's just go there and use that ID to search for. If you want to join our discussion group, while you're logged into Telegram, you can click on this, and it'll bring you into that discussion group, and you can join the discussion group, okay? Or we'll do it for you upon request. Just send me a request and say, here's my premium member, user ID, here's my full name, because if you're using like some funky ID for your Telegram name, we won't know who you are. We can't guess. So, make sure your name is filled in as the party on Telegram. People like to hide their identity there. I'm going, well, that doesn't help us because we can't help you. Because we don't know who you are, we can't let you in. And we'll let you out if you don't give us that full name. We won't even get access. So you can contact me directly, ask for that, or just click here while you're logged into Telegram on your computer and click on this, and it'll bring you into the group as well. So there's 2 ways to get into the group discussion as well as individually ask me questions. Okay? We have other leaders that are also on the Telegram app as well. You can ask questions of, like Lauren and so forth. And we added a link here today under the tax section. We have tax questions. It's not really what we want to get into. We don't want people to think we're giving you tax advice. So we give you basic resource information here. The first one is a good source to go to that you'll see on the list here. You can click here and request information. Just follow these directions. You believe it or not, you can get a lot off IRS.gov. Here's a page called What is Tax? A great way to break down what actually is being taxed and what is not. It's a good way to learn that. So there's a chart there you can see if you click on that. There's another website that goes into discussing the difference between filing or not filing, that sort of thing. Get a lot of these kind of questions. But the one thing is after you've already got yourself into the problem is you can't really back that up very easily. People try status things. They try these other things. You can't You can't buy the insurance after the fire starts, but you can do things to minimize the damage. And today we'll talk a little bit about acceptance and that sort of thing. So keep that in mind. Our other coaching options, we just updated that a little bit. So if you want more information about various coaching packages, pull down this menu here, and there's various links you can go to get that information. A few slight price adjustments in case you're interested. Very minor, but we did add one additional package. So click here to see what the options are. I'm not going into all that detail today. And we also have a new coaching package. There's no link up on it yet on the website, but it is involving how to do a full constructive administrative process to completion on various situations. We covered that on our last call a couple of weeks ago. We're still working out a few details on that, but that coaching option will be available too, and it'll be on that list of coaching options once it's available. You'll see it there. And so far, we got 1 or 2 test cases going through right now. So far, so good. But it has to do with doing acceptance and a conditional acceptance the proper way to completion. And that is a private coaching option. I have a third party who comes in, so they do get paid. They don't start until they do get paid. But that's just how we hire people. The man's worthy of his hire. A lot of people don't like that. They go, well, how come you're not doing it for free? Well, then we wouldn't be here if we were doing everything for free because we wouldn't be able to function. It's just even a biblical principle, an empty warehouse can feed few. So we have to try to structure things in a way that keeps us sustained so that we can help. Now, let's see. Subject of the day. Well, hang on a second, though. I'm going to check here on something. See if our friend... I'm just looking to see if somebody's online here. Do not raise your hands yet, folks. Just seeing if Lauren got online today or not. There's Lauren. Lauren, I made you a co-host. You can mute and unmute yourself. Are you there?
Yeah, TJ, you there?
Yeah.
Hello. How are you?
I'm doing good. Actually, it was a nice day out here on the West Coast. It's pretty nice. Can't complain.
Well, things aren't so nice here. It's cold, a lot of snow. But anyway, we'll get past that.
Yeah, you live for that up in that north central United States. That's no way. I got the worst cold in my life after going through that place once. It was horrible.
Yeah. Well, things are kind of interesting. I'm getting a lot of different, shall I say, feedback from some of our students. Some of the judges in courts are saying that the Constitution doesn't apply because of COVID-19, which is emphatically not true. But the
Constitution says the COVID clause.
I mean, they're doing all kind of crazy things. I mean, we have a document that we sent out, and they don't want to deal with it, so they want to strike it. The judge is actually writing the motion to strike it, not the prosecutor, but the judge is filing a motion to strike the appearance document. He doesn't like that, without any rhyme or reason. It's just kind of interesting, and when you challenge them and ask them findings, facts, and conclusions in law that we use to arrive at this decision, the judge is at a standstill. He doesn't have any. He just wants to get it out of his court because it puts him on such a hot seat. I'm running a lot of places that are saying the local statute supersedes the Constitution. And I just simply have to ask, is the Constitution the supreme law of the land? Just to help me understand. If so, then how can a local statute supersede the Constitution? So I've had a number of those.
They can make that argument. Both sides always make arguments, and most of the time they're wrong. The question is what appellate court decisions support that opinion? I'd be asking them that. Could you provide the appeals court's decisions that state that? That's your boss there, sir.
It's so interesting, DJ. These courts are using the COVID-19 honestly as a scapegoat. It's actually, they're just using it as a scapegoat. You don't get to really face your accuser. They put you on a Zoom call. We had one of our people go on a Zoom call, and I kind of listened in. I just kind of listened in. And it was hilarious when he told the judge said, "How do you plead?" He wouldn't plead. They went around for about 5 minutes, and finally the prosecutor drummed up some nonsense that he found, and then he said in the appellate court, it says you have to plead. Like, no, I don't think so. And so then they, did their usual, and we came back with a conditional acceptance, and the whole thing after conditional acceptance pretty much stopped. They were like, they have anywhere to go.
Yeah. But see, most people, though, would say no, or you can't do that. They make a statement. I'm actually going to go through an analysis of how that works here on the call today, but that's a really good starting point for that discussion and why we end up in trouble.
Right. Absolutely. So I've been doing a lot of that and helping a lot of people get through that. And these courts really don't like that appearance document at all. They really don't. I mean, they do anything in their power to get rid of that thing. They're like, oh, my God, get this thing out of here.
That's exactly why we use it. But, we provided it to all the members, but when it comes to the slam dunk premium, those guys doing that, we give you a little more direct insight about how to approach that because they're going to try to test you and throw you off.
Yeah.
So you got to be able to hold on to your position the right way.
Yes.
The right way.
Yeah. So that's been my week. My last couple of weeks, I've had a number of phone calls, a number of people that are in a number of. I find a number of the situations are very similar. A lot of people are in the same situation, the same boat. I got these DWI, I got these driving under influence. I got a bunch of crimes. I got some crimes where people weren't even involved, and they're adding them after the fact. And I got public defenders that are saying they're not going to withdraw, but they're not going to sign a contract, and they're not going to withdraw. It's like, what is that?
Well, it's like Well, you just conditionally accept the offer upon proof of claim that I haven't already, that you basically won't protect my constitutional rights. I need you to put that in writing and swear to it.
And so they're just, I mean, TJ,
No.
these courts are just scrambling, and they just kind of, they're just out of control.
Yeah, they can't roll it right through simple. They aren't dealing with it right now.
Right.
And don't make it easy.
So
there's a way to do it. Okay.
Yeah.
Well, anyway, Lauren helps out a lot with the criminal defense slam dunk approach that we do things. It's a very, very narrow, specific way some things are done. We don't go in there and argue all your case and the stuff about your wife and your daughter and this and that and the other thing. We just get into the court's inability to move forward without you having all your rights fully implemented, and it's just a way you execute that puts them on the spot. So that's what the slam dunk is all about. If you're in a criminal defense situation, look that up. urlaw.org/slam dunk.
All right.
Okay.
Yes,
then anything else? Otherwise, I'll move on.
Yep, that's it.
Okay. Another, you can hit your own self mute because I made you a co-host, so you'll just stay on. If you want to come in and chime in, you just do that. That's a new setting on here. If you're really, hey, I see Lawrence is on here. If you're interested in commenting, Lawrence, feel free to raise your hand, and I'll pick on you. But Lawrence is somebody else to do a lot of discussion with today. We had a good talk about this concept we're going to get into. Maybe I'll wait till after I give my presentation, but I'd like you to chime in, if you wouldn't mind, and add your thoughts at the end first, Lawrence. Lawrence, so just keep that in mind. I'll just have you raise your hand at when we're done. So let me switch over here to, maybe else has your hand raised. It's because you have a testimonial you want to give. Otherwise, it's not time for questions. All right. So I'm going to switch over here to a document that I put together. I'm going to explain a concept to you. And it isn't just a concept. It's a very, very real thing that we're dealing with. And this is what I'm going to teach you will help you deal with your kids better, hopefully deal with your wife or husband better. It'll help you resolve many of these potential legal issues earlier before they become a big problem. It's very hard to do this, though, after you've made all the mistakes. So keep that in mind. Hard to buy the insurance after the building has burned down. Okay? A lot of people come to us and expect that, oh, well, these guys will help me figure that out. No, we won't. We're not here to perform miracles. We're here to show you how to use a little common sense. But a lot of people don't know this common sense. That what you've been taught to do is just the opposite of what I'm going to go through here with you. But this little chart here, by the way, this document is available in your downloads under the general file, and I think it's called a creditor or debtor. What are you? Something like that. Creditor or debtor. So, when you're in the premium member area, be sure you go find this document if you want to print it out. I would tell you what, I'd print this out and put it on your wall next to your desk, and just keep this in mind. I want you. This is a visual aid. This document will be, because I can tell you, most of our problems is because we're in the capacity of a debtor. And I'm not actually going to try to go too far down this rabbit hole, but this goes all the way back into even biblical history and before, but the Bible does have a very good rounded way to explain what's happening here. And because the Bible has many references to be the lender, not the borrower, or in other words, the creditor, not the debtor. It references don't be double-minded. Don't try to be both at the same time. It references acceptance for all your past sins and future sins. Okay? If you accept Jesus, He will redeem all of your past sins, your debts, and all your future debts, because He put you in the position of being a creditor with the ability to redeem those future debts, your future sins as well. And in the King James Version, it talks a lot about debt, really about debt, not sin. It changes the word to debt And it's been recognized in the Supreme Court that the King James Version is really the foundation of much of our legal system today. So it all ties in with this idea, though, of being the debtor and the creditor. So let's go back to, first of all, let's talk about Jesus on the cross. Now, I don't care whether you're a Christian or not. What I'm going to explain to you, you will see that it makes perfect sense, which is why I believe in that, because it's scientifically proven to work. You know, what do they tell us now? Follow the science. Follow the science. Well, this is science too. And this is science that has been proven and stood the test of time, though. It's not just some temporary theoretical science. It is a science that has proven the test of time. It's not just psychological. It is like gravity. It just works. Plus equal, attracts negative. And if you go a certain direction, you get a result. If you go the opposite direction, you get a different result. So when Jesus dies on the cross, it says, he was essentially saying, hey, that book of Leviticus where you had to sacrifice an animal and you had to give substantive payment for every debt. I mean, you scratched your nose the wrong way. There was a sin for that. If you looked at somebody the wrong way, there was a sin for that. And there was all these crazy sins and debts that you could create. And so to pay the debt, you had to pay it with substance, like blood from an animal, sacrifice a chicken. It was always give something of substance. The problem is eventually everybody runs out of substance things for which they can pay their debts. Now you may think, well, that's all a bunch of, theoretical religious stuff. I'm not talking about religious as well. I'm talking about the actual physical world. So up till that time, we had to use substance to pay debts. Now let's go to the bankruptcy of the United States in the 1930s. Well, up to that point, if you wanted to get a loan from a bank, the first thing they'd do is, well, what collateral do you have? You'd have to put up some collateral, something of value, okay, right, to get a loan. There wasn't any just giving you a loan without collateral. That was nonsense. You see some old movies, they always talk about, hey, well, what can you put up? It's a Wonderful Life. There's a point where you start to give away money, and they go, well, what can you put up? Well, I got this, I got that. Okay, we'll give you some money for it. We'll give you some money. It was always based upon something of substance that you could put up, though, in trade as collateral for the loan. That type of lending is the more credible type of literal loan that's based upon substance. It is not based upon a theory that you might pay in the future or just credit in the future, okay? So Jesus dies on the cross. He says, I will redeem and take on all your debts. All you have to do is accept me. In other words, accept my existence, the belief in me, the belief in this, and we're going to call it the belief in this process. Once you believe, I will take your debts on. Not only will I take them on now, but I'll take them on into the future. I'll give you grace into the future. So if you commit debts in the future, all you got to do is say, would you redeem that? And I will do it. So in other words, they're prepaid. This is what people have talked about, this concept called accept for value. Well, that's what you're doing. You're accepting something for the value that you might hold in the future that you can use to set it off. Let me put that another way. So when you receive a bill, for example, all right, well, on that bill, and I'm just hoping I don't mess up my graphic here. I wasn't planning on doing this, but let's say that they say you owe $1,000. Right? Let's say you owe a $1,000 bill. Now you have your choice. You can take it down here as a debtor, which is what most of us do. We say, well, there's $1,000 due. It says you owe $1,000. But in that that document they give you is a plus value. It's not a negative $1,000 on the bill. It's a plus amount. So instead of accepting it and saying, hey, I'll take that money in the account because that looks like a positive balance in the account, and you go ahead and apply that, we go over to some third party and borrow money from the Federal Reserve, promissory notes, and we take negative money and pay it off, and they will accept that. The problem is now we're all $1,000 further in debt because you are technically in debt into the future. Every time you use Federal Reserve notes, you're creating more debt, not only for yourself but the national debt. You're borrowing from them. Whereas but the bill, let's say I get a credit card and it says, well, you spent $1,000, but you got a positive balance of $1,000 on the account. Wouldn't you just tell them, well, I'll tell you what you can do is just go ahead and take that $1,000 and zero the account. Isn't that what you would do? Because you overpaid last month or something? Well, what if all your debts were all actually overpaid? And what is that? How's that possible? Well, when HJR 192 came along, which is the House Resolution HJR 192, back in the 30s, I think that's when it was, that was built around the concept of the redemption that Christ gave, which was to accept all past debts and to prepay them into the future. And so at that time they created a new system, the New Deal, they called it. They didn't tell the public this, but this is what it was. It was a new money system. And it acknowledges that all of our debts in the future are prepaid. And then you would naturally say, well, how is it possible that they're prepaid? How is that possible? Well, it's really simple, actually. They created a birth certificate system and a Social Security system, which is called an account. And that account is through which technically all things can be transacted. And think about anything you've ever done in the financial world that didn't involve a Social Security number. Forget about whether they're legal or not. You have to have one. I'm just telling you, it's there for the purposes of doing a transaction for your entity that you were born with, that name. So now, what this system, how it was devised is your future values in financial calculator. Pick up a financial calculator. It has a present value and future value button on there. It has a future value. Your future value is the value of your labor to produce over time. So over here, I don't know if I can get the cursor to go where I want it to go on this. This is kind of funky in Word. Let me see if I can get this to work. It's not going to let me do this. Okay, here we go. FU equals, sorry, I'm just doing this real time and I don't know the functions here. So, what Christ basically says, I'll give you grace on future debt. You can give yourself the same grace by asking, but you have to accept the system. Accept. You get value when you accept. You can't be saved by Jesus if you don't accept Jesus, right? It's also true that when you have a debt, if you accept it the wrong way, if you fight it, you'll end up having to go into debt to resolve the issue rather than simply accept it. So they give you a bill with a plus. Remember, it's a plus sign. It's not a negative, it's a plus. And you're saying, hey, I will accept that bill because you've got a positive balance here. Go ahead. And if then you can zero the account. And the other term is zero. Did you hear me say pay? No. You can zero the account because you're saying there's a plus balance. I accept it. Go ahead and zero it out. That's what an accepted for value is. People think it's this real elaborate thing. And where do you get sort of the ability and the power to do this? It's this future value labor. It comes in and it allows the accounting to be done by pulling credit from the future that you already have prepaid into the account. It's a prepaid account. Or think of it as insurance on the future. However you want to word it, it's a prepaid account. You're saying, look, apply whatever's necessary over there. I will accept the bill as is. Please apply it to my future labor account. Or you do what most people do is they come down here and they become a debtor. And they say, nope, I'm not going to give you any credit for that. I want to go borrow from the Federal Reserve and do it. So when you have those Federal Reserve notes, even if you already have them in your account, you borrowed them. Everything's borrowed. You say, I'll pay it with that, and zero the account that way. The problem is every time you do that, you're just creating more future debt for the system. And so you got the IRS knocking on your door, you got interest, you got charges, you got all these different things that they can come after you for. So there's a big difference between approaching it as a creditor than approaching it as a debtor. And we almost all approach it as a debtor. We figure we have to have money in our account, which is really nothing more than debt in our account. But we can use it to zero, take that negative money and apply it to this positive money and create a zero balance. Or we have the choice to say, I'll accept it, and I'm accepting this to be brought in to do the accounting against my future labor account, which is worth millions. You can't go cash it out. People are always trying to do that. That's just, it's greedy. Anytime there's greed involved, something's not going to work. But it is an accounting system, and you have to choose how to approach it. But see, you can't even be a creditor if you don't learn how to accept what you've been given. Just like if you can't have the grace of Jesus without accepting. You see how it works together? So again, I don't want you to think I'm trying to give you a holy roller, religious lesson here, but the facts are indisputable that these kind of things are what we're doing. And so this future value labor thing does exist. You can do a lot of research on this. That's what HJR 192 was all about. And you're directing your public trustees to administer and settle bills you're given. Now, by the way, this bill could be in the form of an indictment. It could be in the form of a tax bill by the Congress. It can be in the form of a ticket or just a commercial bill. And I'm going to stress commercial bill. This is not for individuals because individual people can't go play in the monetary system like that. But if it's an institutional type thing, either the government or a large corporation, this approach does work. Now, there may be more accounting to do here. I'm only covering the basics, and I'm not going to get into every potential scenario. I can't even tell you how to do every potential scenario. But I can tell you have to apply the whole holistic picture here. Your goal is not to pay the account, but your goal is to zero the accounting. But you don't get this benefit if you don't do it right. So a creditor receives a bill, an indictment, or whatever, and they write accept on it. Some people say accept for value, return for value, blah 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 blah, all this stuff. The ones I know of that have ever actually worked are the simplest ones. You simply say accept or accept for value and sign it. Maybe you put a dollar stamp and autograph that too as an additional consideration for the contract. What you're doing when you do the accept and maybe add the dollar stamp and also an autograph that is you are giving consideration for the contract. You're saying, I will accept this under these terms, and here's some consideration to back my contract. You are creating a contract when you accept something. And I'm going to prove this to you. It's absolutely true here in a minute. Sometimes, though, you say, well, man, there's a few things we need to correct here before I'm going to accept. Because you see, by the way, to accept is not to imply that you did something wrong. It simply says, I want to do the transaction. Okay, it's a form of a transaction language. Okay, it's not to say, oh, I wasn't speeding, blah, 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 blah. No, it's to accept the document and say, go ahead and zero the account. You have the authority. I have the authority to give that to you. I'm the middleman here, essentially. I'm the pass-through account. Use the Social Security account that you have. That's the accounting number. And calculate it against future value and zero the account. And take the positive number that's on here and do your accounting. Make it zero. Set it off. Another way to look at it is like this. Let's say that you have somebody sends you, you borrow money on a car. You have the car, you borrow money on the car, $1,000. And they come to you and say, hey, I can't pay the $1,000. Well, in the old days, you had to have collateral for everything, right? Well, the collateral was the car. So you say, well, here's your car. Essentially, that becomes the payment. So you took what's that other value on the other side of the ledger, the car over here, and you said, here's your car. That should settle the bill, right? Isn't that basically what a collateral-based loan looks like? What we're doing here is saying, wait a minute, we've all been given this future value. It's our future labor, and it also can be used to calculate a zeroing of the account. So instead of going to the car, we live in a non-substance-based system. Non-substance-based. We don't use substance. We use this grant that's been given to us going forward, and that grant is the calculation of our labor. We want to use this system. We don't want to get rid of our straw man and get rid of this and get rid of that. We want to administer it. That's a much safer place to be. It's a more peaceful place to be. You want to have a driver's license? Doesn't matter to me. I have one. I have some terms written on it. I have conditions on there. But it's still just a piece of paper. It helps me get around without getting arrested. It gets me in certain doors. But if I choose to take something that I receive and just simply accept it and not fight it, and I'm saying go ahead and use that future labor value to zero the account, go right ahead and do it. It is that simple. Most people go, it just can't be that simple. Actually, the simpler you make it, the more likely it is it'll work. So, your second choice when something comes at you is conditionally accept it. I mean, say, well, I'll do that if you'll do this. Or, hey, would you please prove the contract says this? That's, mortgage, we'd call that a qualified written request, an administrative process. Sometimes we call it that, an administrative process. That's just where you're testing whether there even is a contract between the parties. Most people can get that. They go, yeah, I can do that, I can do that. But what if you can simply accept it and zero the account and move on down the road? Well, you should always accept it if it actually is a livable thing. If it's just money, for example, accept it and close the account. Why fight? But if you need to, you can conditionally accept. You can ask clarifying questions, but be careful because those sometimes fall into statements and arguments. We want to avoid that. You say, well, wait a minute, does this say that? Does this say this? And, let me clarify. So are you saying this? Are you saying that? Oh, I can accept that. You see, this is a thought process to come to a contract. We've had people, Lauren will be able to tell you a story, we've had people that, they're facing years and years in jail, go through the process, and we say, let's, be on the lookout for an offer. Something they come back and say, hey, let's make a deal. How about, 3 months probation or 6 months probation, and then in a year the thing will be off your record. And the guy actually questioned it as compared to years in jail. You see, you have to know when to accept, too. And in that example, he should have just accepted it, and he screwed himself up. He conditionally accepted it at best. When he actually had an acceptance, he could have taken. See what I'm saying? You want to move to acceptance as soon as you can. Your job is not to fight. The other thing most of us do, and this is maybe the most common thing, we start making statements. Well, I've got my status for this, and I've done that, and or maybe you don't have your status, but you're claiming to have it, and you're saying, well, you can't pull me over. You're just a corporation, and you're this. Like all those things might be true, but are they going to help you resolve the problem and get out of there? Statements usually get you into more trouble than not. Oh, I read the IRS code and it says this, that, and the other thing. And I read this Supreme Court case. And, of course, you forget about the appeals courts that actually overrode that case. You didn't bother looking up beyond some template you got. But you start making statements. That usually puts you in a very bad place. Silence is another problem. And by the way, 5 and 6 are interchangeable. They can go either order, but these are the 6 things that we commonly do. Silence doesn't mean you just didn't say anything. It means that, hey, they came at you and they said, here, just pay this $10 fine and you can go home. And you say, well, I'm not going to do that because I wear size 9 shoes and I've got this and I'm that and I have rights and you people are just a bunch of criminals and yada yada. But you never addressed the actual issue. Did you assault the person? Gosh, if you assaulted somebody and there's a harmed party sitting there as a witness and you go off on a bunch of other things that are irrelevant, when there's a harmed party, it's going to get you if you don't address it. Okay? If there's a harmed party, a lot of things don't work. Another thing we commonly do is deny, argue, or we say not guilty. Or even say guilty. That's actually entering into a form of a contract. You're not doing any acceptance. Or we argue. That's, going becoming a defendant. We're rejecting the offer. They can't enter this, they can't do this, they can't do this. So denying, arguing, rejecting, or going silent, silence is a form of doing that because it doesn't mean you don't say anything. It just means you never addressed a winnable issue. Look for the winnable issue. And debtors, usually, this is how 90% of the people, maybe 95, 99% of the people start at the bottom and go this way, bottom up, instead of top down. You're looking to get here as quickly as you can and get out of there. But most people start here, and then they spend the next 3 years of their life in pure hell, either fighting it or dealing with the court system because you're denying, arguing, rejecting. Instead of, what if it was something you simply could have accepted? You may have to swallow your pride sometimes to accept, just like confessing to your sins swallows your pride sometimes, but it resolves the issue quickly. And you have to choose which are you going to be? Be a lender or a borrower? Be the creditor or the debtor? Be the master or the slave? Which direction are you heading? Bottom up or top down? And every time you have a situation come at you, ask yourself, is this a bill, an indictment, a charge? Listen to the word, charge is a bill. Could you simply accept it and collapse it and close it? You know, if it doesn't involve a real harmed party, maybe you can. If you endangered people, like you're driving drunk and you do it pretty repeatedly, you know what? They may not accept your acceptance. They may not even make you that offer. But they may even have a dollar amount on it. But it's still a bill. Okay? So sometimes Congress passes things called bills all the time. And who do? What they're doing is when they create a bill, they're creating a debt. And they're passing it on to the debtors of the country. And it goes on to the national debt. And it creates more debt. And then through the IRS, they collect on that. You pay for the bill they create. When they give you a stimulus check, they didn't give you a stimulus check. They gave you a debt against your future. It's like taking money on your own credit card and giving it to you and saying, hey, we did something for you. But that means you still got to pay it back one way or another. Maybe not directly, but indirectly. That's all they're doing when they're giving you money from the government. They're giving you your own, they're borrowing money and letting you spend it, and then you get to pay it back with interest through taxes, fees, regulations, and so forth. So you see what I'm talking about applies to the whole system as a whole, and it applies to your own individual situations. Now I know when this is over, you're going to ask me, well, how do I just set off a debt? Well, I'm giving you the basic understanding of how to do it. The rest you have to research yourself, because everybody does have a DTC, Department of Trust and Commerce account. Everybody can set up a Federal Reserve account. I'm not going to give you coaching on that. That's not my thing right now. But you can go look it up on their website, because the only way you do it is you follow their directions. And then you can appoint a fiduciary, which is an IRS Form 56, to appoint the Treasury to settle your account. If you need to go that far. A lot of people are successful, though, at dealing with issues right up front by accepting. Another way to look at this is this. In the Bible it says, Matthew 18, verse 15, 16, 17, go to your brother and settle the matter quickly. That's being an acceptor, a creditor. So you become an acceptor. You say, well, what is it we need to do here? Oh, okay, we can work this out this way. Let's just do that. Or you say, well, if you can do that, I'll do this. That's conditional acceptance. Then when you all agree, you go back to accepting. Or you ask clarifying questions because you don't understand something. So you start making statements, silence, deny, arguing, rejecting. It starts to get worse. You end up in court. So I hope you understand this is a way of approaching problems. It's a way of approaching public offers. It's a way of approaching government. And at some point, you want to get to acceptance and get out of there. If you can say, hey, you said I owe you $100,000, but you put a $100,000 plus sign on the account, on the bill, that means I got $100,000. I accept that. Thank you. Go ahead and settle it. See, you're directing them as public trustees to settle the account. Another thing we can get into is how everything is inside of a trust. So when they come to you with something, they're forming a trust. There's a public trustee, there's you, the beneficiary, and there's them who are offering this bill. But you go in denial. And you say, well, I don't have to pay that. Or you say, well, pay it with Federal Reserve notes. I'll go borrow some money from the Federal Reserve. Even if it's in your bank account, you're still borrowing, and pay it that way. Okay, fine. They'll take that. The reality is they already gave you the money up front. You just didn't use it. Because this kind of money can be charged against this, and you don't do it. So when you don't do it, you go down here and you do this, which is fine. You can settle it. But in some point in the future, for the use of that Federal Reserve note, you're going to pay interest. You're going to pay more taxes on it in the future. And it's a perpetual debt system. So I hope that makes sense. You may have to watch this a couple times. I went pretty fast through a lot of it, but I want you to get the basic concept of this concept so that you begin to apply it to your situations. And I mean, this could be a relationship situation. Your wife could say, we're making fish for dinner tonight. And you'll say, sounds good. That's an acceptance, right? Not that hard to figure that one out. Or your wife can say, you said this, you said that. And you say, well, actually, I said this or that. But just to clarify, but I accept what you're saying. Or your wife might say, you lied, you're a piece of crap. You can say, I don't want to argue about this in your head. You're saying, I accept. Yes, you're right. I lied. I'm sorry. And doesn't the matter get resolved quicker that way? Or if you can carefully conditionally accept, because your wife can't put too many conditions out there. But you see what I'm saying? There's a way you handle the confrontation. If you deny or argue or reject, she goes, well, I got this recording over here. You're dead. And that's what happens when we go to court. We go in there and start denying, rejecting, defending, and then they got a piece of evidence. Well, too bad. And as I said, this won't work if you actually did the harm. They're going to get you on the charge anyway. But maybe you get off easier by accepting something and getting off light. Sometimes you do have to take a hit. That's just the reality. Some people have gotten too far down the road, and we can't bail you out, but we can tell you how to minimize the damage. There are other people on the website who will say, well, just go become a secured party creditor and all your problems will go away. No, sorry. It might help you in some situations if you know what you're doing and if you're listening and if you know how to properly do that process. This is simpler because it just uses common sense. It uses biblical authority. It's like gravity. You can't get away from this. This is just the way the universe works. And you can deny the Bible. You can deny Jesus. Go right ahead. But try to tell me that this doesn't apply. This is where he was teaching us how a commercial system and our relationship systems can work. And it's like gravity. It's hard to get away from. You might get away with it for a little while, but that airplane's eventually going to come down. Okay? So anyway, that's my overview of creditor-debtor relationships and how that works. Now, what I want to do is talk about a little bit more about Lawrence, I think you're on there. I don't know if you have any additional comments that you might be able to relate to this, scenarios that you can think of that it relates to, but I'll go ahead and I'll pick you for now and see what happens. Are you there?
Hello.
Hello.
Okay. You hear me?
Yeah. What are your thoughts on what we just covered?
There's so much in there. And I'm loving the fact that you showed the 6 little signs there of a creditor. But I have an interesting question here I totally didn't think about. So what would be the difference between payment and settling? Is payment something that what surety would do?
Well, payment would be grabbing something you physically have and offering it to settle it. Yes, you are offering it to settle. But what you may be paying with is debt. And when you're paying with the Federal Reserve's debt money, you're adding to the national debt. You're borrowing every time you touch that stuff, every transaction.
So payment's a lot like a conditional acceptance. It's just agreeing to pay for the now, but the problem's still there.
Yeah. And instead of saying, hey, you showed me credit on the account, that kind of credit I can use my labor credit against. Settle it that way. And that actually pays down the national debt, by the way. You're holding it in reserve. You're giving collateral back to the system.
Correcting the accounts here.
You're zeroing the account. The word is zero versus pay. It's doing accounting versus paying. Paying throws us off by using that word. We can't pay a debt with a debt. A negative with a negative is a double negative, right? It doesn't zero anything. It works for the sake of temporarily they can accept it and zero it that way, but the reality is it adds to the national debt every time you do it. Using our reserve, our collateral, if you will, brings real money back into the system, if as real as it gets, and brings down the balance.
And let's go over some of the 6 points.
Creation system. So they give you a ticket. What are they doing? Are they giving you a ticket?
They're giving you a bill.
Or are they offering you something? They're offering
Here's
you a bill.
Here's an issue. Hey.
And
I know I got that same issue right now.
Yeah, and they're saying, here's the money. What are you going to do? You're going to pay this. You're going to call this a debt and pay debt with a debt, or are you going to zero the account, accept it? And you're going like, yeah, but I was only going 5 miles an hour. Da, 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 da. Where does that put you? As soon as you say, yeah, but.
Puts you right in the debtor position, because you're not. Puts you right at the bottom. Well, I should say right before the bottom. You're denying, not going silent yet.
Yeah. Or, like I say, 5 and 6 are interchangeable, but yes, it puts you at the bottom. And whenever you start from this position, you almost have lost before you start. Because if you think of it in terms of Christ, I don't accept Christ, but I want you to do something for me. I want you to forgive my debt. I want you to forgive my sins, God, but I don't like you. I don't believe in you. How do you think that's going to work out?
Oh, you're not agreeing to settle anything right there. You're just arguing. You're going around the issue at that point.
You don't want to follow the rules. You don't want to follow some simple rules. Go to your brother, accept it, settle it. The Bible's an instruction manual on how to conduct your business and life. I don't mean business in just a money sense, but in a sense, everything is a commercial thing. It can be quantified. Just like, listen, syntax. Syntax is all about mathematical quantification of language. It's just like a computer. A computer doesn't recognize words. It recognizes numbers. Actually, it doesn't even recognize numbers. It recognizes on and off signals. And a sequence of on and off signals equals a number. That number might, if it put a combination of numbers, might equal a letter. But you can't change that. That's a fact. That's what a computer is. But just like this is a system that's been around. It wasn't just invented when Christ went on the cross, but what he did is he clarified it for us. He gave us the tools to do it. And again, you can look at that as a spiritual sense or a physical sense. I just look at the simple fact that that's to me is proof more than anything that it happens and it's real. And it's not just a spiritual thing. It really manifests itself in the physical through the everyday things that we do.
You take that right there.
Right.
In the Old Testament, right? People were paying with blood, right? So it's payment. And then Jesus shows up, and then he gives you the ability to settle a debt.
Because you are using what? Substance or non-substance?
You're trying to use substance, but there's only a limited amount of substance.
Because you're bartering something, right? That's substance.
Yeah.
But we don't have that anymore. We can't have that. It doesn't exist. We're not going back to it. You think everybody living in the city can grow enough animals to pay all their bills?
That'd be an interesting sight to see. But no, I don't think so.
All these people say, we want to have the little green high-rise buildings with little gardens on the top. You think you can grow enough food to pay your way through? Now, you have your labor account. Use that, your future value labor, offset your bills. People say, well, it's theoretical. Actually, it's not theoretical. I mean, there's people that do it. But it's work because they're going to try to, the devil only has one source of authority, and that's the ability to deceive, right? So they're not going to make it easy. But it's worth learning.
No, they won't.
It's hard to be a Christian, but it's worth learning.
Certainly. Oh, wow. That was pretty good. That was a good one.
Yeah. It just fits. I mean, I don't know how to get outside this and having anybody really be able to say, well, this is just completely wrong. But unless they're only speaking from a non-spiritual perspective, they won't be able to see it. But not just, it isn't just spiritual. It literally manifests itself in the reality of everyday transactions and everyday, the way the system was built and why our whole commerce system even works. Why do we have a birth certificate? Why do we have a Social Security account? Why do we have a Department of Trust and Commerce? It's to track all this. Otherwise, what's the point? You think they gave you a Social Security account just to give you a retirement check? Well, yeah, it sort of comes from this. I mean, believe me, when they say, oh, there's going to be, you're not going to have enough, they're giving you a pittance of your value in that Social Security account, and you don't have to pay in the amount that you take out. That's the other thing about this. There's no way to even do it. I don't know how they come up with the math on that. Should be a lot more than that. When they talk about, people, it's socialist, they're going to give this new idea, they're going to give all the kids $3,000 a year or something for a kid to try to end child poverty. Well, if it's done right, that can be done without costing anything.
Right.
But they're not going to do it that way. They're going to create a bill and put everybody, they want everybody in servitude to them, so they create a bill and see if you'll accept it that way.
See if you're going to fight, and they can bind you to it.
Yeah, but so they're constantly creating more bills, more public debt. They call it public debt, and they're managing the public trust. It's a trust, and you're letting them do it. They're making you offers, and you're accepting it as a debtor instead of accepting it as a creditor.
That kind of leaves an interesting issue, though. The whole socialism part, right? Revolves around the idea of society, right? So, is it possible for somebody to go ahead and make a contract in your name without having a contract with you to make contracts on your behalf?
Yes. Why?
Well, if there's a trust involved, if you've got accounts, like that,
there you go.
Deny it.
I was looking for that word, trust. See, they're administering your public trust, and if you go silent and you don't tell them how to administer it, their job is to administer it for you. We're not telling them what to do. When we get these offers, everything's an offer. It's not a bill. It's not an order. It's an offer. We're not telling them how to administer it. We're telling them we're incompetent. You go ahead and figure it out for me because I'm a debtor. And that's what 99% of us do, don't we? We say, okay, give me a little bit in Social Security check here. Great, thank you. Thank you so much, Lord. Lord government. And
thank you, bull, right?
we fall from grace into Hades. We go from the top to the bottom. And we're underneath everything instead of on top of it.
Wow.
See?
And everyone gives the excuse, I don't get enough time to figure it out. Oh, I'm too busy to do this. I know. This or too that.
Dancing with the Stars is eating up your time, or football. Hey, I watch some football too, but then I'm done. I move on. But some people make these things their life, and they're so busy with being busy, they're distracted is what they are. They're not thinking. And who's going to explain this to them? You know me. I explain things the way it comes to me to explain it. Nobody tells me how, but I listen and I go, well, that's a great way, but I do it this way or I say it that way. Everybody puts their own creative juice into it. This is the simplest way I could ever come up with to explain what is really a difficult concept for most people to get, because the internet is full of garbage. A lot of it is actually planted garbage, so you just know this, to make you make mistakes, and they keep you in the system and confused. If people knew how much disinformation or misinformation, which is intentionally giving you bad information, there's a ton of it on the internet, and a lot of people are chasing it, and it leads to nowhere. A lot of conspiracy theories. This is what we're talking about here is not conspiracy theory. It's a very practical tool. You can prove it to yourself. It may not be easy, but it does work. I've had people on our calls, where I tell people, look, maybe you should just go see what you can work out. And then they come back and go, they made me this great, sweet deal. I said, did you take it? No, I had to pay $100 instead of 10 years of my life. I didn't take that. I want to win. Okay, wait a minute.
Well, what's winning at that point?
You have to say, wait a minute. The reality is You need to get to acceptance and get out. Even if it costs you a little, don't, you pick your battles. I had somebody come to me, and I won't name names or anything, but he's like, I keep getting these tickets from the Homeowners Association. I said, well, why? Because I'm not supposed to park a certain way. Then I said, why don't you just adjust how you park, or, work out the amount, because you want to turn your life upside down and, all this over parking. I mean, come on, pick your battles too sometimes, people.
No joke.
I mean, you can learn to get along as a society. I agree not to run people over that cross intersections. Well, but I don't have to have a license, so I can do what I want. Well, come on. We have to have some sort of agreeable way to live together. And sometimes we have to develop rules. You want to go to space? Trust me, there's nothing harder than learning how to go to space. But the freedom of going to space would be amazing. Wouldn't that be the ultimate freedom? But you know what? To go to space, you have to follow more rules than just about anything there is. But you get a freedom when you get there. You do have to work at it a little bit. Right? So here we've been given a gift, and we don't know how to use it. And the more people go away from God, the more they take... I got an echo in the background. Mute yourself or something?
No, I don't. I'm by myself. I don't think
Lauren,
there's
are you on?
Oh.
Somebody's muted themselves. Okay, echo's gone. The point is you got to accept. And again, I'm not trying to get holy roller on everybody, but the reality is this works the same way because it works. Deny it all you want. And you'll end up down here even better all the time.
Yeah, I'm totally with that. Well, even the word freedom.
Living
right?
on the earth.
It implies... well, without boundaries, right?
If it wasn't hell enough under Trump, we just made it worse by choosing the lesser of two evils. Right?
Ooh, but that still means we chose evil somewhere.
Yes, we did. Well, because he promised stuff.
Yeah.
Give it. Oh, yeah, give me my stuff. I'll take it. Cakes and circuses. That's what the Romans used. And
no
guess
joke.
where you
Let
end
me
up.
cake in a moment.
Yeah. So there you go. Anyway, I just wanted to get your thoughts on that. I'm going to see if anybody else up here has. I'm going to get to the success stories because there's a meeting coming up tonight. I got to get off here so we get to it in time. Those of you who don't know who John Birch Society is, it's a good organization to be part of. Look up John Birch Society in your area. Lawrence is actively involved in that in our area. Bill, you want to get yourself out of the house. Thank you, Lawrence.
Okay.
You can mute yourself. Those of you who are there's also another group called People's Rights. If you get on Telegram, they actually have a lot of groups. While you're on Telegram, you can look up People's Rights, and those are different groups that are available. I've got to get you something muted here. Hang on a second, guys. Okay, still hearing background noise. Lawrence, are you still on?
I don't think so. You hear me?
Yes, I do. So you haven't muted yourself. Okay. *6 or on your computer you can press mute. All right. So, okay, what I'm going to do is I'm going to get to some, start off with, somebody mentioned HJR 192 is dead. Yes, that was the foundation of it, but it's been in the 1971 and the Gold Act. That's sort of the way they renewed it. It goes into that, but that's not relevant. It's still, the monetary system is still what it is. That's the point. But that was the actual basic way it got renewed. All right. And I don't ever rely on that when I make the statement. I'm just trying to point out that it was the formation of how to do it for our system. It was only a resolution, in fact, but you have to go to the issues like the Federal Reserve Act, the Social Security Acts. That's where it all actually happens. All right. So next question. I have to have it in the queue. Nobody in the queue right now. Irma, you're up. Do you have a success story, or what's going on?
Well, I have a question. Can you hear me?
Yes, go ahead.
Hello, you can hear me?
I said
Hello?
yes. Go ahead. Yes, go ahead.
Okay. I have a question about my driver's license. I signed the form without prejudice, and the card that comes with it, I signed it without prejudice. In Canada, we just have a little box that we have to sign, and in that box, I wrote without prejudice and then my name.
Is this
and it has been on my driver's license.
Okay.
And I'm not getting it. And a lot of my friends in the Truther movement, they have gotten theirs like that. But mine seems to be a hiccup.
You didn't get the license?
Yeah, I don't have a driver's license currently. They won't send it to me because I insist on signing it without prejudice.
Okay, I can't tell you why they did or didn't do something, but what do you think it is?
That's
a
policy.
Qualified acceptance. That's a conditional acceptance.
Yeah, exactly. So
if they question, like I've had that happen where I'll write something on there like that. That's called a conditional acceptance. You got to know what you're doing. It's not without prejudice. It's a conditional acceptance with limited conditions. And I've had them stop both me and my wife and two of my kids getting their licenses. They all stopped and went, "Whoa, what's that?" And then my response is the same to everybody. Similar situation like that, I said, "Well, that's how my attorney requires me to sign. Are you giving me legal advice?" And I always end up with that question. Then they go, "Wait a minute. No, I can't give you legal advice, and I can't tell you to not do what your attorney says." And they go, "Okay, fine." And then they let it go. That's how I handle the interaction of that.
Yeah, I've said that before, that my counsel is the word I used, recommended that I sign it like that, and it's not coming back to me that way.
So they send it to you later? Is that what they do? Or did you, is it where they give you a temporary one there? How do they do it?
I signed the temporary one without prejudice also, so I can just keep going back into the office every 3 months and get a new temporary.
Yeah. Or you can ask them, maybe there's something else going on. I don't know. I mean, how would I know? You can say, hey, what's going on with my license? Have you talked to anybody?
Well, my friends seem to have been able to get it. I tried talking to the
That's not what I asked you. I asked you, what have you done to follow up?
Oh, I called the office several times, and the office said that it had been. It said it was approved, and that it hasn't been printed yet. But it's been.
Well, would you put that in writing, and I'll carry that around with me with my old license in my pocket until you send me the new one or something. You just get something that's approved to cover your butt until it arrives. I don't know what It's going to be an administrative thing, having nothing to do with it without prejudice.
Well, I recorded the conversation on my phone. So
okay. Well,
I have some.
If you get pulled over.
Yeah. I have my passport signed without prejudice.
Yeah. Now, if you see my passport in the syntax area, it's got a lot more than that on it. I do a full contract on mine.
Okay.
Thumbprint stamp, seal, copyright, copy claim, and they just push me right through. I went through once when I had a serious issue going on, and they're like, "Yes, sir. No, sir. Go right through." I was like, "Oh, wow, that worked." So, I have to have a thumbprint stamp, a postage stamp, and an autograph on an acceptance on my registration too. So I'm not leaving it unclosed as an account. I'm actually doing an acceptance right on that with the postal technology. And the time or two that I've been pulled over using that, they immediately return it back to me and say, "Have a nice day." They don't say anything.
Well, I just wrote it on. Yeah, I just wrote it on my driver's license because I thought, well,
that's a good start. I take it to the next level, but you don't know until you get tested. See what happens when you get pulled over. Hopefully, nothing happens, but all you can do is say, "Well, then where is it? Keep telling me where it is." I don't know. That could be a procedural issue. I don't know anything about, but that's got to be internal to them.
I will write them again and say, "Where is it?"
Call talk to them in person if you can, and say, would you mind putting something in writing that you say I've been approved, but where's at least give me the temporary and whatever until it shows up. To explain to me why isn't it showing up? What's the big deal? I don't know.
Yeah.
Who knows? They may have a processing error. They might be blaming the COVID on the people who, hand stamp them or something. I don't know. They're making all kinds of weird things these days for incompetence. All right.
Well, I think they're picking on me. I think they're picking on me because a whole lot of my friends did the same thing at the same time, and theirs is coming through.
Well, I wouldn't assume anything. I never assume. I follow through and I hammer them. I say, hey, look, what's going on? I need to know where's my license. You say it's approved, but where is it? Well, I need it. If they're telling you there's a problem, then process it. Yeah, squeaky wheel gets the grease. Same old rule applies. Okay?
I'll squeak some more. Thank you very much.
All right. Thank you. Next caller is Christine.
Can you hear me?
Yes, go ahead.
Hello?
Go ahead.
You know what? This is the first time, and I'm sorry I didn't really mean to hit the mic. I'm trying to learn how to print this thing you told us to keep by our desk. I'm sorry.
So do you have a question? I'll go to the next caller.
Yeah, well, I have so many. I just want to listen and learn.
Okay.
Thank you.
You got a question? You bet.
Appreciate it.
You bet. Area code 321. 321. Go ahead.
Yes. Hi there, TJ. This is Demetrius in Florida. Long time no talk. How you been?
Yeah.
Good.
How you doing?
Good. I'm doing fairly good. I was listening to you talk about the debtor and the creditor. Actually, I got a small question about that, and I got a reference material question. That one's quick. Can a person in a bankruptcy situation use the creditor's information, like you were talking about, in the debts of can they use the creditor, agree with them and just let it come out of the account, like you were talking about?
Well, there's probably a way to try to figure out how to do it, yeah. I can't tell you step by step. Would have to go through it more carefully because everything is tied to the original contract. So you have to look at the document and you have to decide what is it in that document they gave me that I can accept, and then accept it.
Yeah,
we'll tie them up a little bit because usually when you go to bankruptcy court, you're going in as the debtor. They even call you the debtor in bankruptcy court.
You do. You're right. But, I mean, could you turn that around? And then, have you ever known of a case where the person used the creditor portion of it, not the debtor's portion of it, and the bankruptcy court kind of went along with it? Say, oh, that's fine. Yeah, okay. You accept,
I don't know because, this is the first time I've actually taught this lesson. So not since I started the lesson tonight I haven't heard of it. But, I definitely know people who have done acceptances successfully, but every acceptance is unique. This is not a template. This is what is on the contract? What am I accepting?
Yeah.
You have to be unique to the contract. This is the big mistake people mistake. They say, where's the template stamp that I use for all situations? There is no such thing. And as soon as you get past that, then you'll find it yourself.
Yeah.
You don't understand what you're doing and the why, it won't work. Period. End of story.
Okay, and generally going in like that, will the bankruptcy court get angry with you and dismiss your case because they think you're acting out of course?
How would I know?
No, I don't know. I was wondering if they might have a standard.
I've seen all kinds of things pulled in bankruptcy court. Sometimes they get a little pissy, but it also depends on how you're approaching it and the individuals. And what's going on?
Well,
the individual contract is what matters.
Right.
An offer is being made in bankruptcy court.
Yeah, the person, he's dealing with his house, and he doesn't want to get him so mad that they just say, look, forget it. We're just going to dismiss your case.
Well, don't worry about the emotions. Worry about what you're doing, and are you able to stay on point?
Yeah. Well, whether they accept it or not, see, we don't know. It's like you said, we don't know.
You're the one doing the accept. See, that's just it. You're letting them determine who accepts. It's not their job to accept. It's your job.
Right. I understand that.
Immediately went to, well, what'll they do? No, here's what I'll do. I'm accepting. As far as I'm concerned, I've given you directions to zero the account. Go ahead. It's simple.
But what I mean, does the bankruptcy courts understand this, or is it a mystery to them?
I don't know. Depends on how you present it, I guess. You're asking me what somebody will do in a situation I'm not in. I can't ever answer those kind of questions. I don't answer them because I don't know what they'll do or won't do or like or won't like. I don't care. What I do care about is what I'm doing that I'm accepting, and then I hold that position and say, well, Your Honor, this is already resolved. I've accepted it. You say that there's a total in this bankruptcy due of $700,000, and there's a plus sign on that document. $750, not a negative $750. It's in the plus column. Go ahead and settle the account. You're a fiduciary. There's a trustee standing over here. He even calls himself a trustee. I authorize you to go ahead and I accept this for settlement. So you're not saying pay. As soon as you say pay, you're done. You've just said I'm going back to Federal Reserve notes and debtor status. Exactly. Even a word can screw up your settlement.
Well, I look at it this way. You can present it that way. I'm just speculating, I don't know if it'll work, but you can present it that way. And if they don't want to accept it, then you have to go back originally the way they want to do it. Now, all they can say is, no, we're not going to do that.
Well, again, and you're not asking yes or no. You're saying, well, Your Honor, I don't know how you can do that. This matter's already been resolved. I've zeroed the account. Didn't say discharge. I didn't say pay. I'm just giving you the authority to administer the account. You gave a plus sign on this account here. Yeah. You're free. I've given you authorization to go ahead and settle it.
Okay.
I'm going to my trustee and saying, you guys do it. Do your stuff.
Yeah. Do you have any reading material on this in your forms and papers online?
There's probably, I know we have a little bit in our documents. I mean, I got this document I created tonight, but there's so much. I mean, I've seen a lot of articles people have written, and I've torn some of it apart. I haven't seen anything that's well written enough to use, but there might be some more research material we come up with. People come up with something worth looking at that actually. I've read a ton of stuff, but I wouldn't publish it because it's usually got some good stuff and some bad stuff, so I don't just stick it in there. But
do you plan on?
The concept though is simple. Read your Bible, King James Version. Understand that first. You won't even understand this if you don't understand that. Because the creation of the redemption and the acceptance and past debt and future debt, it's actually debtor's language. Be the lender, not be the borrower. It's a big picture understanding. If you don't get the big picture understanding, you won't be able to put the pieces together to understand the small picture. You're the one that has to look at the contract and decide.
Mm-hmm. Well, actually, Dewey Reams
the concept.
The Dewey Reams Bible is almost
it's simpler. The more I give you, the more complicated it gets, the more people will screw it up. I'm just telling you that this is absolutely true.
Well, I'll look for more information. Maybe you'll publish some more stuff later on if you plan on doing any more research in this field.
I mean, you can look at the history of the Social Security Administration. If you look carefully, there's actually an old pamphlet in 1954. I dug it up once on their website, and it talks about we all have a account.
Okay.
It's just a retirement. It's not just an insurance. It's an account for accounting purposes. You look up the Department of Trust and Commerce. There's some other good websites on the subject that are government sites, so they're not conspiracy sites or anything like that, that have a lot to do. They're administering the public trust. Who's the public?
Right.
Well, there's a bunch of debtors and creditors. Which side are you on when you're speaking, though? Are you administering, telling them to administer it, or are you playing the position of the debtor, which is your straw man, and you're accepting it for the debtor, but you're not telling them how to settle the accounts? You have to give accounting instructions. That's when you file your 1040 return, your tax return, that's an accounting instruction. The reason you're left with a bill at the end, if there's something like you owe or whatever, it's because you didn't actually present the contract correctly.
Oh, okay.
You didn't accept it. You say, here, I left it unsettled, and they send you a bill. Darn it, you had a chance right there right at the beginning, right? I'm just telling you, it's right there where you start the formation of a contract.
Wow, you have to just look for it,
When you submit the 1040, you're opening the door, but you don't tell them how to do the accounting.
Right.
There's an ebook going around out there, might be helpful. It's not all 100% correct, but it's called Zero Year Account. You can search for it. it's got a good basic overview, but then it starts getting into specifics about doing different tax forms and all that. And it may or may not apply depending on the contract.
Okay, I just wrote that down. Zero your account.
Yeah, you can search for it. I'll find it on the internet. There's different versions floating around.
Okay, I'll look for it. The second part, it was just a general question. I emailed you, I don't know if you remember this, about a week ago, and when I joined you way back, I think I've been with you now 3 years, maybe a little longer, maybe less. You at the time had a 96-page booklet, or 96 sheets of. You actually got it online. You got an hour and 30 minutes. You're actually talking about it.
Yeah, that document. I think you're talking about with all these different court cases on there. That one.
Yeah.
Yeah. It's in the folders. I forget what it's called now, but I checked the other day. Somebody asked me about it, so I looked and opened it to be sure that was what they're looking for. It's in there. I think it's in the reference folder, the reference documents. Okay. And now keep in mind, one thing about using Supreme Court cases, especially 100-year-old Supreme Court cases, there's probably been a whole lot of cases since that have ruled in the appeals courts for or against. The only thing that your local court is going to pay attention to is an appeals case that's right above their head. And if you don't find that case that relates to that, that's called shepherdizing. You take the case, you search for appeals cases that use that case as a reference, and then you want to see how they're currently ruling on it. That's what will have more standing in court than that Supreme Court case. The Supreme Court case is just a reference.
Just a reference, yeah.
I put that out. When I put that out, I remember I had a few comments that go, well, but this has old case law. I said, well, yeah, all case law is old until you find the most current. You got to do something here, too. You don't just quote that Supreme Court case because you saw it on a video on the Internet. You take it and research it for appeals cases above the court you're in. Like if you're on the West Coast, federal court, in the federal court, you'd go to the Ninth Circuit appeals cases. And then you find appeals cases that won based upon your argument and referencing that case, that Supreme case, where they used it to win a case. Then you got a winnable combination. Then you can cite that Supreme Court case and, more recently, in appeals court, blah, 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 blah. And that, of course, is their boss. That judge in that West Coast federal court, his boss is the Ninth Court of Appeals. He listens to them the most. You want to win a case? Do it that way.
They're a higher court. I get it. Okay.
Well, they're I just think of it as their boss. They're the next step above their head. They listen more closely to them than anything.
Okay.
That's what moves the court. That's what moves the judge, is what his appeals court above him has done. I mean, I've even seen it done directly to that judge, something that was appealed or either agreed to or overturned. No. Nothing has more powerful than that against a particular judge.
Now, who's
Google Scholar?
Who's above the appeals court? The Supreme Court.
But only what fraction of this? What less than 1% of the appeals court cases ever makes the Supreme Court? There's far more good appeals court cases to go with than Supreme Court cases.
Yeah, that's interesting. Wow. That person that.
If it's in the state, if you're in Florida, go to the Florida Supreme Court or the Florida Court of Appeals, whatever they call it. They have different structures. You go to the next court above your court and find case law that supports your position in the law.
Yeah, mine is the 5th District in Daytona Beach. Yeah. Mm-hmm.
So the 5th District in your state, now this is state court versus federal. If it's a state issue, then use that one and search Google Scholar for that state court. And you put the subject in, or if you know a Supreme Court case that might have referenced it, you can use that as a search. And you come up with enough of these that eventually you go, well, this one here makes the most sense. It got overturned, which means that somebody won the appeal. And, now I can use that because it makes my argument. Another thing about using appeals cases is use the finding, not the dicta. This is a very important technique, too.
What does that mean?
People quote comments. They make all these long-winded comments, but the comments are not the order. The comments are just a discussion they had, and people quote the comment. Well, this so-and-so judge said, blah, 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 but that was just his opinion. That's not in the ruling. That's just an opinion. You want the finding of the court is, boom, 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 and it's very short and simple. But people quote dicta, this discussion. That's not usable.
Yeah. TJ, is that found at the end of the motion of the brief? More than likely it is, right? At the end.
Yeah, if you're reading an appeals case, it'll be down at the bottom and it'll say findings or something to that effect, or conclusions. It's that where they make the ruling. It's that ruling you use. It's not the general discussion of two judges yammering back and forth. That's just opinions.
Yeah.
And then a lot of people do that, and it's a big mistake. So when you see a document and it quotes Supreme Court courts blah 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 said blah 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 blah, you better go look and see was that just dicta or was that actually part of the finding?
Yeah,
You get blown out of your case and lose because you didn't look it up.
Yeah. Wow. Okay, TJ, thanks you for your help. By the way, that was me that probably emailed you about I'll check the reference material like you
parking
said.
thing. Yeah, I think that's right. Yeah. I don't use names. I don't want to ever embarrass people, but, it's just bring it up if you don't want to bring it up. So,
If I can help somebody else.
You keep getting yourself over, I call it grass cop issues.
Yeah. Yeah, okay.
Sometimes I write the check and leave that alone and move on to the bigger ones if I have to. But figure it out. Okay?
All right. Thank you for your help. I appreciate it. And have a good night. Bye now.
All right. Take care. All right. Liddell appears to be next.
Hello.
Liddell, go ahead.
Okay. My question is, I'm getting sued by Elga Credit Union for a repo that happened like 2 years ago. And
car repo?
Yep. And I was looking at the three-step process as a...
Is this over? Have they already taken the car?
Yeah, it happened like 2 years ago. And now they
want issue tax papers and all kinds of stuff like on the chargeback or, write off of the debt, 1099s, all that stuff?
No, not I didn't get none of that stuff. They just want $13,000 now, I guess. They sold it at auction, and now they want the rest, I guess. So my thing is I was going to go with the three-step process.
No, hang on a second.
Okay.
Who says you owe it? Who's the party contacting you?
They hired attorney Chad O'Brien.
Are you sure they hired them, or did O'Brien buy the debt?
I'm not sure of. That's what I was looking at. That three. Yeah.
So we're at a conditional acceptance. Who are you? What's your relationship? Did you buy the debt? There's a whole bunch of, we have creditor letters you can send them, which are conditional acceptance letters. Well, that's what the administrative process is a conditional acceptance.
Okay.
Saying, hey, if you can prove X, Y, and Z, I'll pay you. You're not fighting them.
Right.
You're not saying, no, I won't. You're saying, well, hang on, before we do, I need to know, let's see, you've just represented that you're representing so-and-so. Would you provide us the contract for that? Or did you buy the debt? And if you did buy the debt, show me the contract we have.
Okay.
You see, you start qualifying. These are conditional accepting. I'll buy this if you say that. Oh, you say this, I'll say, okay, great. When we get to the point where we can all agree, then I can do an acceptance. I'll say, well, I'll tell you what, I'll make you an offer. Or maybe why don't you tell me what your best offer is? If they can answer all the questions, which they usually can't, then I'll go ahead and make you the offer, or we can talk about an offer. It's all a negotiation.
Gotcha.
And then they may think, well, you give us 3 now and we'll go away after you've asked all the questions because you put pressure on them. You show that you can expose them. Or you can fight them and they'll take you to court and they'll probably win because they're good at court.
Yeah, I was trying not to go to court. I was trying to so that's why I was going to send these letters off, but I just wanted to kind of get
when you send those letters, sure, you customize them specifically to your situation. Those are examples, not templates.
Right. Okay.
And make sure that you can back up every question and know when they don't respond, what they're doing or saying is lacking a response or and so forth. But you're trying to your goal is to come to an agreement.
Okay.
Always, you're not trying to get away with something. Everybody has to get that out of their vocabulary. We're trying to come to an agreement, but we have to have, before I can accept, we have to eliminate all the conditions.
Okay.
Just like any contract you're negotiating. Okay, that's good. Okay, yeah, you're this. Yeah. I'll tell you what. And then we get to the point where you're like, okay, I guess I'm going to have to work something out on the money in this thing. I'll tell you my technique.
Okay.
I want them to make the offer. I don't want to make the offer. I'm ready for your offer, but you need to tell me what the very best you can do is.
Okay.
And then if they come back and say, well, $6,000, you say, well, okay, wait a minute. You're not even, I can go to court and you're not even the creditor. You don't have a contract. You really, is that really the best you can do? I would give them a couple little like snags. That's conditional acceptance. And then sometimes they come back with a lower offer. And then boom, I go, okay, I can work with that. I'll just deal with this and get done with it. Look, you did borrow the money with knowing you were borrowing money. You did know you put the car up as collateral. So you probably should be aiming towards a good middle ground as opposed to how do I get away with not paying?
Okay.
Even though you gave us the collateral, there's a deficit for sure. So, but get the best deal you can. That should be your goal, and negotiate fairly, but firmly.
Okay, and there's another twist to that too, because not only I'm the plaintiff, my ex, which we had divorced and everything, my ex is also a plaintiff too. So
this is filed in court?
Well, yeah, it's a real.
Oh, I thought you were just making the offer. You weren't in court. Okay.
Well, this filed in court because I had checked on it Monday, and I was like, wow.
You can still go to them and say, look, here's how you see. You do the same thing, so the letters aren't going to be as effective once you're in court, because the court won't recognize it. It's private. You should have done this sooner.
Yeah, I didn't know.
Because once it's in court, you're under a new set of rules. Now you're under the rules of evidence, the rules of procedure. Are you following those rules? So when you respond to the summons, then this is where you start asking questions. This is a form of a conditional acceptance, but in court. Your motion to dismiss because the other party doesn't provide the proof that they are the party in interest, and they can't speak with first-hand knowledge of any facts to the contract. Can they? Can they? Or are they going to have a witness who's going to testify that other party gave you actual money off their account and they have a loss? They can't produce that. So you may get into a discovery request right off the bat, asking for the same things, but in the form of a discovery motion. But you got to do it in the rules of evidence, rules of court now.
Okay.
Administrative is much harder to do after you've got you into court.
Yeah, because I didn't even know. And
so the court they'll just say he didn't respond to the summons with a motion or something. You got to file the motion right away.
Okay.
Because otherwise they start the clock on you.
Okay, so find a motion for discovery?
Yeah, that's one way to do it. Have you studied the How to Win in Court Without a Lawyer course?
Yeah, I'm studying that right now, too.
Get through that as quickly as you can. Talks about several ways to respond to the initial offer. It's just usually it's usually a procedural thing you just throw in, and that buys a lot of time. Then you can do your motion for discovery and the whole thing. First, you can simply motion to dismiss or motion for a more definitive statement. Those kinds of motions. Read about it in the course. Look for that, how to respond, and then come up with your best motion. Put it in. Because if you do nothing, you go silent. And you're not even really arguing. You just went silent because you failed to even respond correctly through the procedures. If you miss the procedures, you'll lose the case.
Okay.
Then you go into now they'll start to reschedule things. They'll schedule things out once you do the response. If you do nothing, they'll just go right to a motion to dismiss, and it's over. You're over. It's done.
Right.
Motion for summary judgment. You don't want to give them that chance. So look up how to do a quick response, an initial motion. Do not be silent. Silent causes you to fall automatically. Then look up all the things. Look at those documents that we have for how to do administrative processes on creditors, but you put that into it. Just filed, say, motion for discovery, and then boom, point 1, I want this. Point 2, I want this. Point 3, it's very short, little bullet point discovery items, one at a time. Don't put them all into one sentence, because you know what happens? If they provide one of the items, you put 10 things into one paragraph. This is a technique I learned. If you put 10 things in one paragraph, a bunch of sentences, a bunch of things, they can deny one of them, and then they're all denied.
Yeah,
so you make
Dr. Gray.
1, provide evidence of the contract with the creditor. 2, provide 3, very short little demands. Then they have to address each one point by point in their response.
Okay.
Okay? That's the little tip I have for discovery motions.
Awesome. Okay. All right. So I'll go back and look at the discovery motions and the initial motion response. And
do the initial response. Remember that they'll tell you, don't file an answer, file a motion. And read the different types of motions you can put in, very quick and simple. You just got to do something.
Okay.
Then that buys you more time to get the rest of it ready.
Awesome. Okay. All righty.
You're in the game once you get that far. So you might as well play it the right way. And they'll be surprised if you do it right. Most people, they count on 90% of the people completely fail this step. And then they get a summary judgment.
Because that's exactly what I was going to do. I was just going to go and send off the letters.
No.
Wow, okay. So
That's pre-trial stuff. That builds a record. So you can go to trial and say, motion to dismiss, the other party fails to state a claim, and here's proof, which would be your completed set of letters.
Okay.
See, that was what you can't file that because you didn't do it. So now you got to rely on something else. Delay and silence are really, really costly.
Okay.
If you've been in a conditional acceptance and working to an acceptance, it would never got this far, would it?
Nope.
Nope. See, there you go. See, that's why I say, and you never want to be greedy, but you want to be stubborn, but don't be greedy, and then you come to an agreement. As we say, come to an agreement with your brother. Matthew 18, verse 15, 16, and 17. Read those. That's the order of things. You missed 15, you might be at 16, which is the procedure, and then finally, if you got to go finally to trial, that's 17. It's all written out there how to do it.
Okay. All right, cool. Thank you so much for your help.
Yeah, you got it.
All right.
Next caller is Glenn.
Hey, TJ.
Glenn, you're up. Go ahead.
Hey.
How you doing?
I'm good. How about yourself?
I'm doing well.
I just got a citation, nothing major, so, disregarding stop sign. And I was looking at your different approaches in your traffic folder, and then I went to the county's website to check. They gave me a compliance date. I have to reply by the 18th with either apply for traffic school, which is a lot more than what the ticket would be, and then the other one is pay the ticket, and of course, that's automatically traffic school and paying the ticket are automatic guilty pleas. And then, like you said with the silence thing, if you don't reply, just ignore the ticket, then they consider that a failure to appear.
Mm-hmm.
And they say you may have your license revoked or suspended. So out of all these approaches, I was just wondering if this happened to you, which approach you would take. I saw the one for like $143.
Okay, and what is the what's I going to ask you?
Traffic school.
Have you had another? They're offering traffic school to abate that, or what does the traffic school accomplish?
It's 4 hours of class live. You can't take it online. They said this judge doesn't allow that. I wonder why. Probably because they have a monetary interest in the classes.
But what does it mean?
What do you mean, traffic school?
What is it? What benefit does it give you?
Oh, it gets rid of the points, which is only 2 points, and I haven't had a ticket in like 25 years, so I'm not really worried about that.
It's not going to kill your insurance or anything, probably.
No, I don't think so.
I have the type of insurance where they give you, like, you get one sort of freebie anyway. So if you pay a few bucks more, and then they just waive the first issue. Anyway, so it's probably 2 points is not a big deal. You know what I mean?
No.
Again, we have to decide what pit battle you want to pick. I can't tell you which, but this might be where you can. I would first of all, right now, I just write accept. Is there a dollar amount on the ticket?
Yeah, sure is.
So, this is one thing you could do. I'm not telling you what to do. It's something I'd look at it. I'd think, what feels right for me? And I might write accept and sign it, put a $1 stamp on it, and send it back.
Okay.
I don't check any of the boxes. Now they may sometimes they'll just interpret that as a non-response, But if you write it next to the guilty thing, because they'll say, well, where's payment? And they say, well, I included the payment. I gave you the authorization to apply the credit on the document to the account. Okay, that's one way to do it.
You put the $1 stamp on the ticket itself?
Where I sign.
Okay.
Like I put over the signature line and sign over it.
It's funny because when the cop handed me
don't use abbreviations or anything. You literally use your full, middle, first, full, middle, and last, upper, lower case, and sort of almost printed on there. Upper, lower, first, middle, last, and that's your proper autograph. That's not a signature. Signature is when you just scribble something, and it's something. It's not the full name.
Right, and that's what I purposely did.
That's a straw man.
When he handed me now they don't have paper tickets anymore. They're all electronic, so they hand you the little iPhone thing. And so I wrote without pledge because I couldn't fit it all in the screen, and then I just put my initials at the bottom, and that's it. And he said, "You didn't sign." I asked you to sign this, and I said, "Well, that's my initials." And he goes, "Okay," and he just turned around and walked off. So,
hey, legally, U.S. Code 1, Section 1. Any mark is a signature on their documents. Even typed one.
Even without prejudice on top, that doesn't make me contract with them, right?
That's not addressed there, but it certainly establishes that they don't have something. But remember, they're going to move forward and ignore it to see what you do. So you ask me to tell you what to do, I won't do that. But I will say there's the options.
No, I'm not.
You can do an acceptance. You could simply say, I've done the first ticket I ever got. I just wrote a letter with it and sent it in and said, here it is. How much I sent the fine in. I said I apologize. Whatever. There was something going on, and they sent me back. I said, can you give me a better deal? And they sent me back half the money, just because I kind of came in on her.
Right.
You can do the acceptance and do an acceptor for value style. You can go the syntax route, and ask questions, which is essentially a conditional acceptance. That's what syntaxing does. It says, hey, I'll agree to go forward on this contract, this offer you gave me, but I need you to eliminate all the potential fictitious conveyance or language, because that's a postal violation, a violation of 18 U.S.C. 1001 and 1002. Just so you know that, just eliminate that so you don't have a problem. And then you'll probably end up in court arguing that. But so it depends how far you want to go, what you want to learn. Some people use traffic. I know one guy. I have one guy. All he does is he intentionally goes and breaks. He goes and parks in the handicap zones all the time. And when he gets a ticket, he says, I can tell me he did it like 24 times. And he won every case. Because there's an exception in the law. Have you read the law like to the letter, really, really carefully and slowly? That's charged?
Yeah, I went through the. Yeah, I did. I went and looked it up and just
there's so many ways to approach things. There's no one way. It depends on what you feel you can resonate. If you read it and go, it says you must do stop to a complete stop or something where it's sort of like, wait a minute, what does that word mean? I need a motion for more definitive statement here.
Right.
Sometimes that'll hang it up. If the cop.
Yeah, I'll go back and look at the statutes again, but. Because
the contract is not just the document they gave you; it's the statute too. It's on the document.
Yeah, I understand they always redefine words all the time, just like in a tax code.
Well, no, it's
everything's
just that
redefined.
you read it and think you understand it, then you read it again and you say, wait a minute, it doesn't say that at all.
Right.
And sometimes, people say, you were near a stop sign. I said, would you please identify the near point that I didn't stop, or something.
Yeah, and I like the way they don't say you run the stop sign. They say you disregard the stop sign. I want to say, no, I regarded it. I regarded it as I slowly went by.
Disregard means you should. That's a negative prefix word. There's your syntaxing coming in. And, I didn't disrespect it. Disregard. But wait a minute. Dis is a negative prefix word. But what is regard? It's no guard. So I double negatived. I must have regarded it. You see, it's a word pepper game because they have a double negative. Disregard is, a re is a no. It's to pull back.
Okay.
So you can go into syntax and say, well, this is how I interpret this to mean. Would you please reword this so it makes sense? But if that's not in the code, well, that's too bad. You kind of expose the fraud just on their language usage.
Yeah, and what does guard mean?
Because they know those laws are not
G-A-R-D.
Yeah.
Yeah, I know. That's why.
Well, you might this is where doing etymology. There's a website called etymology.com, and you can break down word parts like that and you actually find out what they say it means. Now, does that mean the court is using those definitions? No.
I doubt it.
They're using presumptions that you understand the whole context. Disregard, I know what that means because you're here arguing it. You didn't bring up the word itself. Or maybe there's another word in the statute that doesn't actually add up to what you did. Look it up in the statute.
Right.
Sometimes I find right in the statute a word. Like I did this a couple of weeks ago. If you look up the call, I think it was two calls ago, we went into the mask mandate. Right?
Right.
I said, where do you have evidence that I date men? I like girls, so stop telling me I have to mandate. You know what I mean? But it sounds ridiculous, but the reality is that's how stupid it is that they're trying to do it.
Right.
And then I said, wait a minute. But it also says, right in the notice they have in the business, there are exemptions. And if you have a mask, this, that, and the other thing, you can file exemption. And you can't ask why they have the exemption. I saw a video last night where somebody did right here in my town. This guy was trying to get into the VA hospital. He says, I have a mask exemption. And the guy says, well, that just means you have to wear a mask. And he goes, and you have to tell us why. And I went, whoops, I'm sorry. Let's pull up what it actually says. It says you do not have to say that. Case closed. He would, if he just stopped there, document it, go to court, or send him an administrative letter before court, say, you told me that I have to disclose it. Here it says I don't. I'll see you in court unless you want to settle this now. You see, you got leverage by attacking that one word. So be sure, do a good review of the statute and say, they don't have evidence of that.
Right. Okay, I will. I'll look them up. I looked them up the other day, actually. Because that's the first thing I usually do too, is just go to the statutes and see exactly how they word it.
Read it for the words, each word they have to. You would say for them to win their case, it will say something around these words. To prove their case, they must prove. Okay, what does they have to prove? What is it they have to prove? And if you say that they can't prove this point, you can drill them on that point. What evidence do you have to prove that I hadn't stopped at a certain point? What proximity to the sign do I have to have stopped? I stopped 10 feet back, or what? I mean, what are they saying happened? And then you say, well, what evidence do they have that I didn't?
It's just going to be the officer against me, basically. He's the
No,
witness.
but you need to ask the right question. That's my point.
Right.
The question that you can win on. Just make sure you ask that. Well, let's not get to another call. You have to cut this on time tonight.
Thanks so much.
All right, take it. Tao Lee. I got more callers than I can get to, so everybody's got to make a quick question. Tao Lee, is that how it's pronounced?
Oh, it's Thule.
Thule, okay.
Yeah. I'm new to this. What you're talking about and so forth. And my situation is actually pretty simple. I had an infraction for, they say driving, but I say moving in a automobile.
Well, you had an infraction. An infraction is a no fraction, so you didn't break any of the bones. Good, thank you.
Correct. So I did go to the plea hearing. I was trying to tell. I was telling the judge I don't understand what you're accusing me of. And the moment I said that, he said, and he paused it. And it's a Zoom meeting, so he paused it. And he said, "Look, if you don't give me guilty, not guilty, or no contest, I'm going to enter not guilty plea for you." And so he unpaused it. And again, he asked me, gave me the code that I violated. How do you plea? And I said, again, I don't understand these codes.
No, that's a statement. I'm going to go back to my little chart I covered earlier. That's number 4, statement. You're in the middle of nowhere. I don't understand is not the right response. I'd say there is I accept what you're saying, but you need to explain this to me first so I can understand. So it's a positive negative thing, I'll do something here once I make sure you can explain this to me. Now, my definition of this is that. In the statute, it says this, but I understand it to mean that. So I can't plead to something if I can't even accept what it says. So you made the issue something else other than, I don't understand, and then they're going to go like, okay, well, he's incompetent. He's now down here number 6. He's basically arguing. That's a rejection. We're going to just enter the plea for him, and he can figure that out later. You see what I'm saying? Or it's also silence. You didn't address the main issue. Hey, there's language in here that I don't understand. So my understanding of this word is it means that, and it means this. So if I enter a plea, it's because you say that I created an infraction. I said, I'd be honest with you, Your Honor, I didn't break any bones at all.
Correct.
They'll think that's silly, but that's an accurate answer, actually. So to say I don't understand it never works.
Right. And I'm on the site because you have to there's the traffic common law approach, and then there's the traffic jurisdiction approach. And are these just different avenue of ways of handling?
Yeah, there are a couple different ways to approach it. The jurisdiction one usually is the way to go because it's kind of getting into discovery and proof and breaking down the words and really zeroing in a question on that until they break and give you a deal. What was the infraction about? You never really.
It was the plate on the automobile that I borrowed was expired, and so I was driving around with expired tags on the automobile, and the owner actually stuck a current tag from another vehicle on there just so that they avoid. But what I was suspecting, because this cop
wait,
side by side.
You just qualified a bunch of stuff there. You're driving with expired plates. Yeah. And what else? What are you saying with that?
And the second code they said that was valid was the owner stuck a current tag from another vehicle on there.
Oh, so you have a fake tag now.
That's what they say, yeah.
Well, it sounds to me like that's what the facts would show, right?
Yeah.
I'm just trying to show you how quickly they can set you up.
Correct.
Done. Case closed. Because
when it comes to
because then there's knowable intent, so you got to be really careful there. You don't get away with things. You better figure out how to. Now your situation is this fact will always come out. So the question is, what are you going to do to remedy this with the least impact? That's what I would be thinking right now if I were you.
Okay. Can I challenge jurisdiction?
It took me 2 questions to catch you lying. And I'm not trying to say you're lying, but this is what the court will do.
Right. Can jurisdiction be challenged on that? Because I did some reading on this, and in California, under the penal code, there's 2 types of officers. And one is a code enforcer, the other one's a peace officer. And based on the definition, the code enforcer is the only one that can cite and issue complaints for statutory codes. or
So can you prove that if that's in this case if that's the status of that officer? Because if you make an accusation, you're arguing. You're at the bottom now. You're on number 6. Okay, I'm not saying not to. I'm just saying, but when you start at the bottom, it's really hard to climb to the top. Where are you going to get to the point where you can accept it?
Right, correct.
You got to build a case. So you want to make that argument, which is completely outside the. I mean, it might be true. Can you prove this cop doesn't have the authority to issue tickets in that jurisdiction? Do you think you can prove that? Because you made the argument now. You got to prove it.
Correct. Correct.
See, this is the position we put ourselves in. I'm not saying it's a bad argument. I'm saying now you have to defend it.
So as far as the numbers here, then you're going by the easiest to resolve this to the hardest to resolve this, right?
Well, yeah, it's the whole come from to resolve it. Yeah, in your case, you do have a problem. You probably didn't know that the tag wasn't good, and then you probably didn't know that the one was put on there was not was a fake one. You know, this right there. Your actions speak louder than your words. So, what do the actions show? It shows intent. So you must have known that that was not proper. So you're not coming from a great credible argument position now. You're better off in that situation to say, go stick the sticker on, take a picture, send it in, and say, I already resolved the issue. Here's your fine. You know, what's the best you can do? That's what in that was a situation. That's what I did that once in a situation. I didn't have fake stickers though. I had my own private plate, so I really wasn't faking it. That's what I intended it to be. Okay. Whereas when you take the sticker and put it on there, now you're using their property and modifying it to break their rules. You see this? See the difference? So it's like printing counterfeit money. You know, Federal Reserve doesn't like you playing with their money. It's their stuff. It's their property you're messing around with.
Right.
They can make it really ugly if they want. So, you know, that's one of the situations I would probably work out a compromise and just take care of it. How much do they charge you for that?
They have a trial date for me, so I don't know what they're going to charge me for it yet.
What's this? There's this fine stated on there though.
Let me see. It actually doesn't give a fine. It says total fine due is appearance required.
Okay, yeah, because they see that as kind of a violation now. I would do, you know, in my situation, I would just do an acceptance. It's accept, send it in, whatever they charge you with. You show them a picture when you go there. Say, well, I already resolved the problem with the plates, but I also accept the charge. What's the best we can do? And then literally negotiate it right there.
Okay.
Don't get into arguing about it. It won't go well.
Okay. Sounds good.
Take a picture, replace it, take a picture of it, show your proof, bring your papers, say, Your Honor, I've already resolved the issue, apologize for the error, I accept the charge. Just write I accept and sign it. Don't say guilty, just say I accept, though.
Okay.
Has a different legal effect. What's the best we can do?
Right.
Get it back to acceptance and then just, you know, and resolve that.
Okay, sounds good.
You don't play with other people's stuff. Okay?
All right, sounds good.
That's where I go with it. We can give it fancy about you could try the challenge of this and challenge them on that. But the amount of situations where they it's black and white, shows an overt effort to misuse their information. You better just do an acceptance and close the account quickly. Get out of there.
Okay.
That's not guilty. You might be guilty to the facts, and sometimes you do write this to write, accept guilty to the facts, but not to the charge. You know, that's a conditional acceptance, but that's saying, yeah, the fact is correct. That was a fake sticker, but I'm also doing acceptance to close the account. This is all accounting. For whatever amount it is, take your credit. See what happens. You don't know.
Okay.
Okay?
All right, thank you, sir.
All right. Next caller is 574. I'm on my last couple of minutes, so go ahead.
Yes. I went through a divorce and ended up with all of the credit card bills, and I'd already given her all of our cash, and she supposedly couldn't make my truck payment in like 3 months. 3 months later.
You gave her the bill.
The thing is, to make a long story short, I was in sales. I ended up moving to a different job. I moved to a different state to make money enough to pay the bills that we were accruing when I was doing 6-digit sales. You make bills for 6-digit income. So
yeah.
Anyway, I put in my change of address when I moved to do the new job, and they never came, and I wasn't able to catch up the payments on my motor vehicle. Is a truck, and they never demanded it to be turned in. They never came and got it, and now this last November, they sent me a letter stating that I forgot the exact words, but it's basically that they're claiming that I was unlawfully, how do they say it, enriched by $18,000, which was what their value of the truck was at the time, and that they reported it to the IRS. So basically, they've already discharged the debt.
Yeah, they discharged it at 1099. Okay.
Yeah, exactly. And so my question is, okay, so they never asked for the truck. They never came and got the truck. Now they're saying that I'm basically the owner of the truck. They've discharged it, which also says I'm the owner of the truck. But
who's they? Is
how
this
would
a
I
law
go?
Firm? Is this the lender? Directly?
Oh, it's a bank. It's a bank.
It's the bank. Okay.
The bank that I took the loan from.
Okay. So what's the question? I have an idea, but what's your question?
Well, the question is, if all this stuff that they've done says that it's my truck, how would you go about if you were in this situation?
All right, I'd ask them, first of all, let's say, if you say it's my truck, will you give me evidence of free and clear title? Question mark.
What I was looking for, yeah.
If you can't produce evidence of free and clear title, then you can pay the IRS bill. I'm going to refuse the 1099 and send it back to the IRS and to them. You don't have to accept it.
Well, what I was thinking was they put the amount on the letter. If I accept the letter, does that give me title?
You can conditionally accept it. Well, I'll conditionally accept your claim that I have the title, that you can produce evidence that the title is transferred free and clear. Leave it at that. Okay. Let them file their 1099.
Right, and then just pay the taxes instead of the $18,000.
Right, and that'll be an added income on your tax liability for next year. And then there's other ways you deal with that. But one step at a time is okay. If you say so, that's a conditional acceptance. I can accept your terms so long as you're going to be delivering me evidence of free and clear title at the same time. If not, you can eat your tax liability.
Right.
Which way do you want to handle it? Give them a choice. Negotiate it. It's a negotiation.
Okay.
It's an offer. It's an offer. It's never a demand.
Even though it was way back in October or November?
I don't care when it is what is it? Oh, you mean the letter itself?
Yeah.
Well, yeah, if you have to a certain time to respond, then you did what we say don't do is you went silent. You didn't respond and address it. You may not be able to get back to acceptance. I don't know. I'd still call them.
What if I just send them a letter asking questions?
No, don't just ask questions. That doesn't get to accept and say, I'll conditionally accept your offer. Conditional acceptance.
And see if they answer.
if you'll agree that when you file this with 1099 that you're going to be releasing title and provide me evidence of title. If that's your position, that's your offer. That's an offer.
That makes sense.
It's always an offer. Don't look at it as an order. Even a judgment, it's just an offer. Until you, well, when you just sit there and look at it, you go silent. They go, oh, there you go, it sticks now. So I conditionally accept your offer. Thank you. Prove this or provide me this evidence so we can go ahead and go forward with this. Now, they probably already put it on for last year.
Yep. So on a different note, if you have a summary judgment from, say, a credit card, and you write back to them making an offer, if they negotiate, is that considered like reopening the contract?
It depends on the circumstances, I guess. What do you mean by what negotiating? I mean, where is it actually at?
Well, supposedly it's $11,000. Of course, that's been accruing interest, but they already, in my absence and without my knowledge, they sent to an old address, even though I put in change of address. They sent to an old address.
So they've said to you, they've sent you what? What does it say? What's the offer?
Well, the court already gave them a summary judgment.
Oh, so it's a summary judgment. Okay, this is done. So yeah, it's just you waited too long. It's going to stick. You're going to have to probably.
I mean, I didn't have notice. They didn't.
Well, then you're talking about probably having to go back and do a whole sort of motion for a void judgment because of you've lacked getting notice, and it's going backwards is very hard to do through a case, though.
Right.
You slipped on your rights, you lose them after a certain time. Depends on the statutes and the codes in those states and when and where everything happened. So you have to do some research to see what does the law say about required notice. If they don't comply, you can use that law and say file a motion for void judgment. And there's some information on void judgment in our court material.
There's no statute on lack of notice. Or
then you should cite that when you write them back.
Okay.
You know, because right now you're hearing from the court, right? It's a court order judgment. You'd have to read the material on void judgment, maybe assemble a motion for void judgment, going back to the court, citing the court. You weren't given proper notice. The court might say it's too late. You should have done this within the next period of time to make your motion because you didn't object. Key is if we fail to object, we go silent. We're going to just lose, usually. We don't, because you don't have an appealable issue now. If you waited too long. You may. I'm just saying that's where your problem is.
Okay.
So I'm going to get to one more caller, and I got to get off here.
Yes,
okay?
Yes, thank you.
Thank you. Thanks. Liddell, go ahead. Real quick, because you've been on already.
All right. Okay, really quick. Okay, the brackets that's on the actual templates, like for like
we
your
don't do templates, but they're just examples. Go ahead.
The examples and stuff like that. Are we to put those brackets in there too, like around like the address, their names, and stuff like that?
It depends on how you're approaching the document, whether you're taking a syntax position or not. So which documents? It depends. What do they say? The brackets remove whatever is between the bracket off the page, so you may or may not want them. It depends on. There's a lot of different examples. Sometimes people just give me these and go, "Here's how we did it," and they left the brackets in to identify where you have to change something. Read the whole document and you decide. Put it in your context. Okay.
What do they mean? Like, what do the
Which document are you talking about? I don't have it in front of me to tell you what it means. Because the brackets, some examples of the documents that might be floating around out there have a bracket indicating where you have to change something. Sometimes on the syntax documents, it means, hey, I'm providing this in plain language, but I'm not going to use forensic syntax language, quantum language. I'm using this to substitute for this. So which document are you talking about? And what context are you seeing the brackets in? Brackets can be many things.
Oh, it was a 3-step administration process.
Okay. Like I say, it depends on if it's not syntax version. That might just be, I don't know which document you're talking about. So offhand, without seeing it, I can't tell you what those brackets were used in syntax, in context for.
Gotcha. Okay. All right. That's all I needed. Thanks, man.
Okay.
I appreciate it.
Look at the whole picture. What are you doing? What is it saying? Do you want to use the brackets or not? That's up to you. I don't care.
Gotcha.
All right. Last caller is Peggy. Go ahead.
Hi, TJ. It's Peggy.
Hi.
Can you hear me?
Yes,
okay.
Go ahead.
My question is, we have a property that is in a title holding trust, and the previous owner, who is also a beneficiary in the trust, was served as the trustee, and the address of the property was on it, and you can't read the summons and complaint. And so the company, Provident Holding, was not notified and still has not been notified, even though the county who did this and gave the information to the sheriff, they have a record because we hand carried it in, and they know our address. It's filed with the county assessor as well. They have the address, the phone number, and everything, and they served the previous owner. So is that something
Did they serve the previous owner as beneficiary, or just the previous owner as named?
No, they gave the previous owner the summons and complaint addressed to the title holder, addressed to Provident Holding, and she's an individual.
Well, she should probably send it back, say, I'm not the owner.
Okay.
Create a record.
Okay. That works completely for me, and then I want to thank you because the rest of the information you've been passing out in the last hour has been very beneficial, because now I'm going to follow my jurisdictionary and become the assertion person.
Yeah. Well, your case is if they got you'd want to say just handwrite it. Sorry, I'm not the owner any longer. Keep a copy, maybe give you a copy. Just it might come back to the trust eventually, whatever's going on. But you haven't been notified, and you have proof that they sent it to the wrong person. See, they do have rules about serving the last known address of the owner, but they're not the owner. So it's kind of like suing, like trying to take a president out of office who's not president. Sorry, wrong jurisdiction.
Yes, and that is exactly it, because. And I've even had conversations with the county because I'm a beneficiary of the trust. And the reason I was asked to talk to them is because it was in a different arena. But so I know for a fact that they have the correct information, and they are just choosing to go or try to go through the back door. So
Is the trust, yeah, exactly. They will try to backdoor through things like that with these title holding trusts, but they haven't noticed anything to the trustee. Is the trustee's address on the title? She probably is somewhere.
Well, the address of the property is on the title, but the trustee's address is not on the title.
Okay.
I'm sorry, the trustee's address is not on the summons and complaint.
Is it on the title anywhere, though? It's not in, like, when recorded, return this to...
Oh, yes. The warranty deed says when recorded, return to, and it's got the trustee's name, phone number, address.
Then they have the information if they want to serve. That's fine.
Yes.
And then you get into what does the trust, then you get into what do the trust rules say. If there's multiple beneficiaries, well, they got another problem, because now you're dealing with a split title.
Oh.
Yeah.
Yeah, and I know how to do with the multiple beneficiaries and all of that, because I've been working in the trust arena for 10 years since I met you.
Yeah, you've been doing it a long time, I know. That's why I'm able to use that language and say it to you, and you get it.
Yes.
So.
Oh yes. Yeah. Okay. Thank you.
All right. Nice talking to you, Peggy. Take care.
Thank you. Bye.
And folks, we are out of time. I know I have a few chat window messages, but we'll just have to get to the next call. Lots of good questions. I hope it was useful. Hope this big picture. Take this document, stick it on the wall, stick it on your bathroom mirror, and think, how am I approaching? Where am I at in this process? Am I accepting, or am I at a place where I can't accept? You want to get to there as quick as you want to accept it right off the bat if you can. Or conditional acceptance, clarifying question. If I'm making statements or silencing, didn't respond in time, or I'm denying your extra, I'm really in a bad place. I got to get to here. How do I get there? It isn't about getting away with anything. It's not about who you are. It's a simple matter of how you're approaching the problem. You already have somebody that accepted for you. You have your status. You have both of these statuses, creditor or debtor. Depends on whether you're accepting or not, though. You can't accept the blessings, the grace of Christ, without accepting first. Got to humble yourself a little bit. I do too. Everybody has to. But you see what I'm saying? This all works very well. It's scientific and it's spiritual at the same time. Hopefully this makes a lot of sense to you. I'll get this video up so you can watch it a time or two. Get the document, print it out, scribble all over it, think about it. How am I approaching the problem? And I guarantee you one thing. If you do that as your big picture look at everything you're doing, you're going to get better results. Prove me wrong. So until next time, folks, appreciate you all being here, and we'll catch you all soon.